Now I may kindly invite Professor E.P.N. Udekumara, Dean of the Faculty of Applied Sciences, to address the event.
Very good morning. Thank you very much. Professor Dayarathne, Director, UBLC, Sabaragamuwa University of Sri Lanka. Dr. Tilini, Coordinator for the UBLC, Faculty of Applied Sciences. Ms. Taniya, Cell Manager of the UBLC. So it is a great privilege and honor for me to participate in this occasion actually. This is a kind of a timely important workshop. So I must be very much thankful for the UBLC staffers, including Professor Dayarathne, accepting our invitation for conducting this workshop today. With a short invitation, they have accepted this invitation. Then they have prepared for conducting this event. I must be thankful on behalf of the Faculty of Applied Sciences. This is organized by the Student Union. It is having a subcommittee, academic subcommittee. So that was guided by Dr. Tilini. I must be very much thankful to them for conducting or happening this workshop today. The workshop title is Intellectual Property Management, I hope. Intellectual Property Management Workshop. I think this is a timely, important workshop. You can gain more information on intellectual property as well as UBLC activities actually. They are having an array of activities aiming for the staff members, academic, the non-academic, as well as aiming for the students. So you can gain more knowledge from them. So I hope you will be getting more knowledge in relation to the intellectual property protection and management today. And after that you can pass down the gain knowledge with your colleagues actually. It is having a limited members here. So you can pass down that gain knowledge to your colleagues and you can use that knowledge, right? Then I am happy to remind you, Professor Dayarathne, our director of the UBLC, it had a wonderful event yesterday, exhibition, that was organized by the Student Union support. That was practiced by the 1920 students actually. That is a kind of a wondrous event actually. It had 39 stalls, 39 plus exhibits. Then we have invited UBLC staffers. They have visited here, they have observed them, they have selected some sort of important exhibits. Then they promise us to give support to make a platform with your product and the industries. After that, industry people, they visit here, they will observe your things. Then if they are interested, you will be given support to enhance your product further. So with this, because we are late by a few minutes, thank you very much and have a very nice day. Good luck for you all. Thank you.
Thank you for your kind words, sir. We really appreciate the cooperation to make this event possible. Now I would like to invite Manidu Lianake on behalf of Student Union of Faculty of Applied Sciences to address the gathering.
Teacher, UBLC representatives, lecturers, and my dear brother. Good morning everyone. It is my great privilege to address you all on behalf of Students Union of Faculty of Applied Sciences, Sabaragamuwa, University of Sri Lanka. Innovation has become an integral part of our lives, especially in the last decade with the rise of technology and internet innovation. It has brought about many changes to our society and economy, such as improved efficiency, increased productivity, the creation of new jobs, and societal security. Normally, innovation will be accelerated when the human society is forced under tough situation. For example, innovations that were invented during the Industrial Revolution are still using among people. When a society is introduced to limited resources, they tend maximize the use of it. As you all aware, Sri Lanka also is facing very tough situation now economy. Instead of boosting the new ideas and innovation, the government has chosen the path of privatization, increasing taxes and suspension of people's rights. We believe this approach is inappropriate for building economy. Instead, we should conduct a suitable economic policies with new ideas and innovation. Therefore, we believe it is golden time for undergraduates like you and me to make contribution to our economy. As you all know, we arranged the successful exhibition called Immersive yesterday. We believe today's session will be helpful for the young inventors to grow their ideas toward the predicted and beyond that industrial their fresh ideas to a business. As the research group of Students Union of Faculty of Applied Sciences, we truly hope that our brotherhood will continue to show your support for upcoming events as well. Thank you.
Before I begin, let me introduce you the topic for today. It is legal matter that one should own the basic right of the work created by oneself. For this protection, there are intellectual property policies and property protections with level of national and international. The UBLC, which strive to bridge the gap among private and state-owned businesses, the academic committee, faculties, and undergraduates. The UBL has linkages with the universities in the world as well as Sabaragamuwa University of Sri Lanka. Similarly, Sabaragamuwa University of Sri Lanka also has a policy which will be explained further during this discussion. One of an exclusive right granted for the invention, which is called patent, as intellectual property protection. Without further ado, it's my pleasure to invite our resource person for today's workshop, Professor Indunil on behalf of our organizing committee. For the note, he is a professor in finance and director of University Business Linkage. Sir, the floor is yours to provide some valuable information about intellectual property protection and management in detail and refresh our knowledge.
Right. So very good morning to all. Dean of the faculty, Professor Dayarathne, and faculty coordinator, Dr. Taniya and Ms. Amanda. So all are closely attached to UBLC, and Taniya, my manager. Dear students, I think so I have done several workshops in the university, but this is special for me. Why? I have got some invitations from the faculties, from the academic staff, and even from the students, from different associations and organizations. So why this is so special for me is, so I got this invitation from Students Union. It's a very happy news that in order to change the mindset about the Students Union, so by doing this workshop, you can have more visibility about your union activities. So these are things that you should organize as Students Union while doing other things. So you can do all these things, and you can do some priorities for the academic matters also. You all are here to get the quality and quality degree. Right? Okay. So today, is it okay or no? Right. So anyone have you attended any webinar conducted by me prior to this? No. So right. Have you seen our office, University Business Linkage Cell? Where it is? Anyone? Okay. Right. No one has, right? Right. Good. Right. Good. So anyone? Yeah. Anyone has access to our website, University Business Linkage Cell, UBLC? No. That's fine. Good. Right. Good. Right. So before I move on to the before I move on to the presentation, let me first share who we are and what we are for. University Business Linkage Cell. So we have very short history. UBLCs were established in the university system in Sri Lanka in 2018. University UGC issued a circular asking all the universities to establish business cells in the universities. In circular came 2016, but so due to financial difficulties, the universities couldn't establish the cells. But so you may have heard about the World Bank grant. So World Bank grant, they provided some funds to establish UBLC cells in the university system. So we have got about 15 million to start the university business cells in the university. So with that initiative, we have established the university business linkage cell. These are some of the activities we have done up to date. So progress. So we have to meet. We have been given 4 phases, and we have already completed all 4 phases. And we have signed several licensing agreements. So these are the. So we have got some royalties. I will explain what these are later. So what is licensing agreement, and but just to give an awareness what we have done up to date. So this is one licensing agreement. So this came from your faculty, your academic staff. They have invented this wine. So already we have licensed this wine to one of prominent companies in Sri Lanka, Cap Organic. Now this product is ready to launch. We are going to launch this product February. So we have got the approval from the government, excise department. This product came from your faculty. And so we have another product. So this is also we have already granted license to FATNA. And we have got some licensing fees, and also we have got some royalties also. So this also came from your faculty. Right? So we have great academic staff. Right? So great inventors. Right? So we have now how many faculties we have? Right, we have 9 faculties. So your faculty is very closely working with the UBLC, right? Your academic staff members. And this is also another product. We have one license, given license to Cargills. It's in the market now. It was developed by some inventors of Faculty of Agricultural Sciences. And another one, this is another invention. So we have signed the licensing agreement. We have got 1 million licensing fee as upfront fees. Farm Chemical Private Limited, and so we have agreed 0.25% royalty. So you might think it is very small amount, 0.25%, but their forecast monthly sales about 15 million, right, monthly sales. So then we get fair amount of royalties. Right. This is another product that we have already transferred to the targets. So we have got licensing fees 300,000, and royalties we have agreed 1% unit selling price within Sri Lanka, and also the 2% outside Sri Lanka. Right. So we have signed several MOUs with the private and government institutions. So these are some of the highlights. Right. So we have given some publicity to what we are doing also. And so patents, we have applied about 20 patents, more than 20 patents, and local and international patents. And already some patents are already granted, and this is one of the so international applications we call PCT, right? The filing international patents, you will know how to fill later, right? So how to fill international patents, right? So these are the some of the highlights we have done. So this is. And also you also can, as students, UBLC is not only for the academic staff, right? It's for the entire university community, academic staff, non-academic staff, even students. Right? So you can make use of this, right? That activities or the services offered by the UBLC, right? Okay. So these are the among we have 15 universities. So this is the progress we have made. Sabaragamuwa University of Sri Lanka. So we are the highest in signing licensing research agreements, and also the licensing agreements. Also we are in a better position. So compared to even some established universities. Right, local patents, PCT. So these are some of the right. Sabaragamuwa University of Sri Lanka. So we have applied local patents, PCT, and other IPs. Right, other IPs means trademarks, designs, and so on. Right. So because of the progress that we have made among the universities, so we were given an opportunity to attend this TV program, right. So these are the I think you got some idea, right? So what we are doing and what we are for, right? Okay, right. We'll move on to the session now. Right. I think you all are second years, right? So we will see your understanding about innovation and patent protections, right? And we have a quiz, right? So you can get your mobile and you can answer, right? You can read the QR code and we'll see your understanding about UBLCs or the UBLC and the innovations and intellectual properties. I think right. Thank you. Right. So you can see the QR code in the group, your WhatsApp group. You can scan it. Right. So everybody is in now. So we can can start the quiz. About innovation is defined as the commercialization of new product or process, the invention of a new product or process, a new product or process idea, the implementation of new product method, production method. So you can answer. Right. 48%, 33%. You see which one is correct? Right. Okay. 1/3. Right. Okay. So we have very good audience. Right. So what's the patent? What's the patent? Exclusive right granted by the government on invention, license granted by an inventor to a company, legal document accepted by court, publication made on invention. Good. Right. So I should not do the workshop today. I can go. Right. Right. Exclusive right granted by the government. Correct. Good. Why is it so important to protect innovation through intellectual property rights? Because it is advantageous from the commercial point of view, transmitting security to the market and allowing for more economical publicity. So because it is the only way to apply for community funding. Third, because it confirms the exclusivity in the commercialization and it's the only way to prevent third parties from copying our creative initiatives. Because it allows an inventor to keep his or her invention secret. Right, we move to next question. So validity period of a patent is 5 years, 10 years, 20 years, 12 years. Oh, don't Google and answer. Okay, right. So, 10 years. 3%. Right, good. So 20 years, right? So 20 years. Next. A worldwide patent exists. Is this statement true or false? That means if you get a patent in Sri Lanka, it has effect in the world. Oh, good. Right. Fall. Right. Patent right is territorial. Right. So which of the following is covered under intellectual property rights? Sorry. Good. Right? Yes. So you can get the coverage for patents, copyright, trademarks, all of them. So according to the IP policy of the university, IP right is owned by. So we have an IP policy. The university, if you have seen the document, you can answer this question. According to the IP policy of the university, IP right is owned by inventor, university vice chancellor, UBLC. 37%, UBLC, good. What question? So it's good if the vice chancellor and the university allow us to, right, get the ownership. But unfortunately, they are not giving us the ownership. Right? Right, 37%. So which of the following is not one of the three essential elements for patent to be granted for an invention? So we have to fulfill some conditions, right, to get a patent right. And it's not right. It's not. Yeah. Answer is only 80%. So where do you register your intellectual property in Sri Lanka? Sri Lanka Inventors Commission, National Intellectual Property Office of Sri Lanka, Department of Register of Companies, National Science Foundation. Right, good, 70%. Innovation can help to provide a temporary competitive advantage when see who is the top scorer? Huh? Who is Salonika? Salonika? Good, right. You are the top scorer. Unfortunately, I couldn't bring in gift to you, right? Right. Okay, right. So this exercise to just to get to know your understanding about IP rights and innovations and about UBLC. So now we move to the session. So I will give you some, because I cannot give you full awareness about in this session about patents, copyright, or the trademark protections, design protection, but I will give you an overall picture about the IP, because it takes at least one week times to give full awareness about the subject. Right? So vast area, and also the emerging area. You know the so we are in the knowledge economy 21st century, right? So knowledge creates value for the individuals, organizations, and societies, even for the countries, right? So we are in a world where IP is dominating, intellectual property is dominating. Right, so I have titled this session as Role of Universities in USL and IP Trends in the 21st Century. So we are in the knowledge economy. The intellectual property or intangible assets. So there were period where the tangible assets dominated, right, in the balance sheet of company. So now, the 90% of the balance sheet represent in most of the companies intangible assets. So, right. So therefore, the knowledge economy. So this subject is very important. Right? Intellectual property, also an intangible assets. Right. So I spent some time to explain about the university business linkage cell and different type of intellectual properties, patents, trademarks, copyright, designs, and so on. And awareness on IP policy of the university. We have an IP policy, and how it applies to students. And filing national and international patents, how to file national and international patents, and emerging IP trends, right? Right. Okay. Mission of the university. Before before establishment of the university business linkage cells, the purpose of the university is so we have to engage in teaching. That is the top priority as a teaching university. Right? And second, doing research. Our academics and students, they are doing research for their career advancements as well as even students. You have research component in the final year, right? And also you do a lot of community work, right? And students unions, you engage in community work, and also the staff members. So before the UGC's UGC initiatives, so we focus on the mission focus on these three areas. So with this UBLC concept, so another, right? So one important aspect, right, added to the university mission, that is technology. So our responsibility is to put forward, to carry forward the fourth mission of the university. So as the university business, the director of the university business said, my main role is to put forward this concept, technology transfer. So the universities transfer knowledge in several ways to the public. So we do publications and then online and printed versions, and training and educate the students. Once you get out, pass out from the university, you will work in the government and non-government organization, even private sector. And employment of graduates, conferences, you will attend conferences and you will share the knowledge with the public, general public. And also the consultations of academics, especially. And sometimes even students, you can undertake some consultancies in the private sector. So they do consultancies and transfer the knowledge. And collaborative research, collaboration with the industry. So we have signed several collaborative research agreements with the industry, UBLC, and also recently I saw in the social media, your faculty had signed an MOU with to advance the research knowledge in Palma. Yes, I saw. And licensing and formation of startup. This is the most formal way of transferring university knowledge. So this is what we are for. Licensing and formation of startup. So if you have any inventions, you have two options. You can get the IP protections and you can transfer the knowledge, you can sign the licensing agreement. Once it is protected, it becomes an asset or property. So you can do anything with your vehicle, you can do anything with your land, so you can do anything with your laptop. Similarly, once it is registered, it will become your property. So you can do anything, you can sell it, export, import it, abandon it, or even destroy it, you can do it. So we started this university business linkage sales 1980. So with the UBC circular. So this is our purpose. We create value for your knowledge. So our mission is to create value in you. And so when you get out from the university, or when you pass out from the university, you will get at least some of the students. You can get, in addition to the degree, you can get an IP or patent rights. So companies will be chasing behind you. Nowadays, companies chasing behind patents. Right? But it creates more value for the companies. Right? The companies will run behind you. our objective is to, in addition to the degree certificate, at least some of the students, right, you can get a patent right during this period, 4 years period. So you can earn until you, right, throughout your life. Right, I will show you how. Right. And transfer, yes, this is the process. So technical transfer process through UBLC. Inventions, we have 9 faculties. Including new faculty, we have 9 faculties, right? So we have 9, even with the FGS also, right? So we have 9 faculties. Right? So we get inventions from faculties. Right? So far we have got some invention disclosures from, even we have got some invention disclosures from the students of this faculty. Right? Some students, so they know this process. Right? So you can, this process starts with the filling of the invention disclosure form by the inventors. Right? So it is in the website available, you can downloadable. Then once we get the invention disclosures from the inventors, students, academics, even from non-academics. Then we start this process. Yes, right? Once we get the invention disclosure, we assessment by UBLC. Right? So we conduct a separate assessment. Right? So which form of 5P is most relevant for this invention? So that is one assessment. Whether it is patentable, so whether we can get design patents, so whether we can get even the copyright. Right? So most of the inventions coming from the faculties are patentable. Right? So I discuss or I pay more attention about the patents in this session. I give more focus on the patents because most of the inventions, right, are patentable, right? Especially from the inventions coming from the universities, especially, right? Not from the industry. Then so we start assessment, right? Then we file the patents or the whatever the protection filed by the UBLC. So we undertake entire process. Even filing cost will be borne by the University Business Education. So even we pay maintenance costs because we have to annually maintain the patents. So we do everything. Even if we help you to draft the patents also, right? So you can file the, because we will notify the inventions to the UBLC by filling the invention disclosures, and then we start submitting applications to the NIPO. Right? So first we file the patents in the with the local office, and thereafter, so we find industry partner. So without an industry partner, we are not going for international patents because it is high costly. So we are filing a patent application in the US PTO, US Patent and Trademark Office, it costs about 2.7 million rupees. Right? So we cannot afford. But we grant the license to the industry partners, they will pay. But the local patents cost about 8,000 rupees. Still we can pay because we have got some grants from the aid, right? So to file the invention disclosures and notify your inventions, if it is patentable according to our assessment, so we proceed with the application. Right? And then we start marketing process because until we file the patents, we don't go to the commercial or the marketing phase. Why? So it is a resource for you if it goes to third party, so you will lose the commercial value of the inventions. Right? So if you have an idea, great idea, don't share with the third parties. Right? First, file the patents and then you can share it. Because smart people very easily catch up to a technology. Right? Don't share with others. Then, so we start marketing. We conduct the marketing survey and the market value, whether this product is has commercial value, whether this invention has commercial value, right? And target customers, target market. So we do all the market analysis on behalf of you. Then we connect you with the industry partner. So we transfer formally your technology to the industry by signing licensing agreements. So it's a long process. Then it is a legal document, and so when we negotiate, so we have done 5 licensing agreements. We have signed 5 licensing agreements, and we have several negotiation rounds in the tables to negotiate. So first we offer, right, give us 2 million for this invention. Then they negotiate and we come to one point. So we can make the deal, right? Both parties agree on the terms and conditions imposed by each party. Right? So we have higher position and lower position. Before we go for negotiations, Dr. Taniya and all we discuss, right? So before we go to the discuss or the discussion with the industry, we discuss separately. This is our higher position. So we'll ask 2 million, and we have ceiling and floor, right? And so we can negotiate up to even more 1 million. We start with 2 million and negotiate. And companies also, they may come up with different proposals, options. So we should have some options when we negotiate always. Right? Not only for this, to negotiate, you should have some options. Without options, no point of negotiating. Right? Then we get the licensing revenues. We share licensing revenues with the inventors. So we give 80% of the revenues to the inventors. If we earn 1 million rupees, we give 8 lakhs to inventors. Why? So we want to further encourage innovations. So according to the IP policy and also the benefit sharing plan, so this is the benefit sharing plan. If it is an invention, you get 80% and 50% to the department, respective department where the academic is affiliated, or the students also, right? The relevant department of the students. 15% and 5% for the UBLC, right? So we get very nominal margin, nominal percentage currently, but we want to change it in the future, right? In order to, for the survival, for the sustainability of the university. So we are planning to put another new version of the IP policy with some amendments, but still will be giving more percentage to the inventors. So even though, say, you might think that I stay only 4 years period, then after 4 years I will lose, I won't get this benefit. No. It's for, right? Even though you pass out from the university, if you have invented something and transferred your inventions to industry some, right, some conditions, they royalty, say 2% royalty. So for 20 years, we signed the licensing agreements initially, 10 years, extendable for an infinite period. Right? So you will get the cash check even after your graduation. When you go home, so we will send you the cash check. So you get the cash check. Royalties we will send you. Right? So therefore, so you are in the second year, I think. Second year. So you have 2 years time, right? Think of an innovation and let us know, notify. Right? So we will see the possibility of creating value for the innovations. So income, so we have income from product sales, income from IP licensing. So I mentioned you there are two options with your inventions. We have two options. One is we can license it with some agreed conditions to the industry, or so you can become an entrepreneur. So startup, you can form your own startup with your own inventions. So we guide you. So we coach you throughout the period. Right? And also the UGC very recently issued a circular, right, how universities should form startup companies. So my next presentation is on that, how to form startup company as students. So you can get 1 year leave from the department in order to get engaged in the startup company according to this circular. Then you will get, if you start a business or startup company, so you will sell products, you will get revenues. If you license it to third party, you get the upfront fee, licensing fee, so you will get at the time we sign the licensing agreement, and royalties as agreed in the right negotiation, maybe annually, semi-annually, or quarterly. So what is intellectual property commercialization then? Intellectual property commercialization or monetization refer to the act of using intellectual property to generate revenue. So this is revenue generation model. So income generation model. We transfer the knowledge, we get the, we protect your idea with an IP, patent, then we sell it. Right? That is commercialization. So business model. So why you should protect the patent through IP, right? So IP is resource for you. If it goes to third party, you get nothing. You get nothing. But if you get the protections, it will work, right? Millions or billions. If you are not protecting your IP, right? So it goes to the competitors. So competitors will develop the product or the process with your idea. Right? So IP, protected IP gives an exclusive right so that you can enjoy monopoly on the market. So monopoly, nobody can access to your technological area. Right? So like if you have a lab, you put a fence around your lab. That is your property. Similarly, right, if you get a patent rights and if you have drafted claims of the patents covering with a wider coverage of the technological area, right, so others can have access to your prohibited area. That is your property. So value creation, monetization of intellectual property creates value for the inventors. You get revenues, and the university. Now you know the universities totally depends on the present funds. Right? So universities get some revenues, generated revenues. So those money can be spent for students' welfare, for your welfare, and academic staff development programs, and even to develop the infrastructure in the university. You know the world top brands in the world, most of the world top brands, tech companies, Google, Apple, Google, Amazon, Facebook, Microsoft, right? So all these technologies have been developed by the universities. So these universities get trillions of dollars as revenue by license. So similarly, if one of our academics, at least one, can develop very good technology, right? So we can run the university with that. And society, you know, they can spend decent life. So you will get smartphone, mobiles, laptops, vehicles, comfortable vehicles because of the innovations, right? Because of the protection. And economy, we can export that at least for some products, right, to other countries. We can export say we are planning to export a wine at least to Chinese. Yes, then we'll get some dollars. Then if our university can export 10 products, we have 15 universities, so we can export 50 products from the universities. We will get dollars, foreign exchange. So create value for the wider community. So these are some forms of protections. Patents. If it is an invention, you can get the patent protection. Trademark. Apple trademark. Right? So you can develop. This is a business model. So we are not going to. We have filed some trademark applications in order to meet KPIs of our projects. Right? Key performance indicators. Because so, as a university, we are not going to file or get trademark protections, right? We go for patents most of the time, right? So, trade secret, right? Copyright, geographical indications, plant varieties, industrial design, layout design, traditional knowledge. Trade secret. So, we have two options. Say, if you have an invention, you have two options. One is get a patent. So in order to get a patent right, you have to disclose your inventions to the government or IP office. If you are not disclosing it, you won't get the exclusive right. Right? The price for the disclosure is exclusive right. Price for the disclosure is the exclusive right. Because in the patent system, the objective of patent system is to share your inventions, share the ideas. Right? So others also can develop the technologies based on your technology. Right? Share. Or you can keep it as a secret. You can keep it as a secret. So you have an invention, great idea. You are not going to file the patent. If you file the patent, the patent office will publish it. Right? They will publish it. So only thing they can learn the technology, but they cannot develop a product and market because you have got the patent right for 20 years. So after 20 years, it will go to public domain. So after expiring the patents 20 years, anybody can develop the same technology, and more competitors will come to market after 20 years. Then why you then? So your strategy is you are not going to file the patent. So you want to start a business and continue your business for several years, like the Coca-Cola. Well, top trade secret Coca-Cola is still, right? So more than 100 years. More than 100 years. So they have not revealed or disclosed the formula. The formula is known by only 2 people at a time. So they make great effort to keep it as secret. The Coca-Cola is within most valuable 10 brands in the world, beverage sector. So what happens if they have filed a patent? What happens? After 20 years, right? So it goes to public domain, so other companies, beverage companies will develop, right? Will use the same formula, right? So more competitors, similar product. Right? So still it's secret. So these 2 people are not even flying on the same flight. Right? They don't go, right, on the same flight. Right? Secret. They don't know each other. Right? Each doesn't know whether the other knows the formula. Right? Secret. Still secret. Thing is, it's very difficult to keep it as secret. Right? So when they transfer the formula, even they under security squad, they transfer. Right? So we are manufacturing. So we have planting Melanie. Coca-Cola we have somewhere. So they have some franchises, right? So they have granted some franchises, but they don't give the formula. So, right? So they provide only that formula in cans, right? I visited once, I can remember. So they don't. What we do is we here mix some water and deliver, right? According to the formula, right? But then, right? Secret, they don't reveal even franchises. You can do your own business with the, right, by keeping it as secret. So GI copyright, so if you publish a paper, if you put the copyright notice, it will be protected under copyright law. So here, no need to register trade secret, right? No need to register. But patents you have to register. So copyright also no need to register. Once you put copyright notice, it will automatically protect under Sri Lankan intellectual property law. But there is an exception in the US. In the US you can register copyright. And geographical indications, the GI, we have, can you tell me any GI protected product in Sri Lanka? Geographical indication? So we have got GI certification for cinnamon. Ceylon cinnamon. Others cannot use as Ceylon cinnamons. Only we can use Ceylon cinnamon. So this is if you are exporting cinnamons with GI indications, you will get premium price in the market. So there's a belief that Ceylon cinnamons, right, has some, right, qualities. So similarly, the wine, right? So wine, some varieties we call it's not here. There's another protection called application of origin. Application of origin, right? Application. The wine manufacturers, so champagne, right? So you cannot use the name. So they have already got the certification, right? The one geographical region, right? Say, very famous for what? Say, tomato, right? Then we get the EI certification, right? If you can export, but it should be known by, right? It's not, right? If it is not known globally, the quality, so we can get the price. But Ceylon cinnamon, right? So it's globally known. Therefore, you will get premium price in the market. Right? And plant varieties, if you are developing any plant or the food varieties, you can get it protected. But in Sri Lanka, still legal provisions have not been finalized yet in Sri Lanka. Industrial design, so outlook, how it looks like, appearance, you can protect the appearance. So this device, the appearance, even your iPhone or mobile, the home button, they may have protected as design. And layout design, so you can design, even you can get protection for the layout of this whole mini auditorium. Right? So, if you visit to any Apple store anywhere in the world, right, you can see the layout. So they have got the layout protection, Apple store. So you can get the layout, even office companies, if they want to get the layout designs, you get the protections, they can, right? Traditional knowledge. So that is indigenous knowledge. So we cannot use indigenous medicine sometimes, right? We have got the protections. So IP is everywhere. Whatever you do, wherever you go, right, you will be using IP protected vehicles everywhere. Property rights. If it is an invention, you can get patents or trade secret. Yeah? Trade secret. And if it is creation, you can get copyright or design creation. And providers of goods and services, companies, especially companies, brands, marks, trade dress, geographical indications, application of visa. Most of the time companies get the protection for this trade dress, because as university, no point of getting trademarks. So we focus on patents, and so you are like inventors. Right? So you are like inventors. You have two options: get patent or trade secret. Right. So overview of intellectual properties. Legal right, what for, how. Copyright, as I mentioned earlier, so original creative or artistic forms, right? So if it is song, right, or music or drama, right, so you can get the copyright. So we call related right, copyright and related right. Right? If you get a right for the drama that you have developed, it is called related right. If you provide any music for a song, right, so that is related right. So you can get the protection for the music. And it exists automatically, no need to register, no need to register, no need to register. Trademarks, so distinctive identification of product or services. The companies can exclude competitors. You can always go to generic products. So you say, no need to register. Even if it is patents, it must be registered. But trademarks, so if you can prove that I have been using this trademark for 20 years. If someone is infringing or using your trademarks, right, so you can prove in the court that I am using this trademark for several years. Right? So still you have an opportunity to protect it. Right? So initial registration is 10 years, for 10 years, trademarks, and you can renew after 10 years again. Right? And besides external appearance registration, you have to register, and initial registration is 15 years. Yes. 15 years. 10 years of it. That differs 10 to 15 years. Right? So, because these periods may differ from country to country. Patents, the validity period of patents, generally 99% of companies, countries have the same period. Because this patent system has been harmonized to a greater extent. Globally, they have come to an agreement through Paris Agreement. So Sri Lanka was also one of the signatories to the Paris Agreement. So the IP law is more or less similar in the world. Patents, new inventions, application and examinations. There will be rigorous application process. It takes about 2 to 3 years to grant the patents. So several amendments will come. So there's a very less chance of granting patents in the first application. Several amendments will come. And you have to make payments for each amendments in some countries, the US. So they charge $2,500 US, about $2,500 US for one office action. So there may be 5-6 office actions to file the patent with the US PQ, right? So it costs about more than $2 million. Even your mobile is protected with several patents for the several IP rights, trademark, copyright, patents, designs and test secrets. The IP protection for website. To develop website, you can get the protections. So you can protect it under designs. And also the formula, some of the formulas, or the algorithms, right? Or the functionality of your software can be patented. Right? So you can get a patent right for the software. So patents, new technologies. So which component of your software can be protected with patents? New technological system, functionality of the software, search engine or other technical internet tools. So copyright, you can get copyright for your design and and web content, written materials, photograph, graphic and so on. And trademarks, you can get trademark, business names, logos, product names, domain names. If you are doing online business, you can get domain name protected. Computer generators, industry designs, graphic symbols, you can protect it as design. Screen display, right? Graphic user interfaces and web pages. Trade secrets, still you may have something, confidential things. Source code, object code, right? Algorithm. If it is proprietary software, you want share the source code and object code, but if it's open source, so you will there are two types of software developers, open source and proprietary. If it's open source, you will share the source code and other object codes or with the downstream users or developers. So software also can be patented now. But still in Sri Lanka we cannot. The US you can get software patents. You will choose protected with multiple IPs. Yeah. So applications of machine learning, you know now. So there are some patents or inventors. The inventor is AI in the world. Can you believe? Normally, you know the inventor should be a human being. How can an AI develop a technology? Some countries, there are 5 to 6 patents owned by AI. Australian IP office had a grant of 1 patent, 1 inventions, and South Africa. So it depends on how they have defined the inventorship. Right? So you can argue in the court, if the application declined by the office, how you define the inventorship? If they have defined the inventor should be a human being, so you cannot get that, right? But some IP officers, how they have defined inventorship is very vague. Then you can counter argue in the court. Right? So they have given granted patents right to an AI. So AI applications, you know now. So this is emerging trend in the world now. Right? And also this it's a great trend for the human being also, mankind. If the AI can do things done by the people or human beings, the companies will not hire. So these are some, the trademarks developed by universities. Facebook, Harvard. Google, Stanford. So they have licensed these inventions to the industries. So inventors get millions of rupees or the dollars. And type of trademarks, composite marks. So you can get protection for word and design both. It's a bottle, Coca-Cola bottle. They have protected the design and also the word open happiness. McDonald's, Starbucks, coffee. Design plus word. And slogans, with slogans. Always Coca-Cola. It's finger licking good. KFC. You can get protected. Nokia, connected people. Right? And Sri Lanka, you may have seen Sri similar words, some supermarkets, they have used some like Kagi. Why? Kagi මොකක් කරන්නේ නැහැ නේද? ඒ රෝත් ඇයි කරන්නේ? ඉවැක්ෂන් එකට. Kagis පාර ඔයා පුස්සිටි කියන්නේ පුස්සිටි කියන එක. Kagis කියන්නේ පුස්සිටි. ඔයාලා ඒ විදිහටම පොඩි ලාමයි. ඒගොල්ලෝ අරන් නැහැ. එයා මොන පොඩි ප්‍රොටෙක්ෂන් පොඩි පුස්සිටි කියන ගන්න තුනයි ඒගොල්ලෝ. පුස්සිටි කියන ගත්තා නම් ඒ ඩිසයින් එකට කවුරුවත් කාට යූස් කරන්න බෑ. ඒ ගානේ ගොඩක් අය ඒ පුස්සිටි නම ගෑවන්න. නේ? කස්ටමර් නම ගෑවන්න. කස්ටමර් නම ගෑවන්න. Trademark की වැදගත් එක තමයි customer-ට you can go for any product always. benefit company එක benefit දෙන්නේ competitors ට use කරන්න බෑ. customer-ට benefit දෙන්නේ you can any product එකට always යන්න පුළුවන්. දැන් ඒ වගේ පුස්සිටි කියලා ගන්නකොට මම යන්නේ නෑ. ඒක අනුන්ගේ goodwill එකෙන් ආදායම් ගන්න කඩතුන සුපර් මාකට් මම ඒවට යන්නේ නැහැ. ඔය ජෙනෙවිලි අනුන්ගේ ට්‍රේඩ් මාර්ක් එකක් ගන්නවා ඒ ප්‍රොඩියුස් කෝල් එක නිසා ඒක ඒවලු නැහැ. So similarly you have to get protection, right? So if you develop a business, if you start a business or the start a company, developers of trademark, then get it registered. We can even help you to register with the registration. Design marks. So these are design marks. Apple. Design. McDonald's. Word marks. So trade, there's even three-dimensional marks can be protected. Yes, this is a Apple store. If you go anywhere in the world, you can see similar setup. They have got layout design. Even shape of your candy, chocolate can be protected. Shape of the outlook of the Coca-Cola bottle, so you can get the protections. So no company can use Coca-Cola bottle, similar like. Because they have got the design protection. So you can very easily differentiate genuine products and pirated products. Right? Counterfeit. Trademark counterfeiting, pharmaceutical products, genuine and counterfeit one, you can see it's similar. At a time, at a glance, you can identify quite similar. But there's a slight difference. There's slight difference. Genuine and counterfeit one. So a lot of counterfeit products flooding into the market now, especially from China. So they copy the technologies, US technologies, and come up with some copies. Samsung product, can see copies. Counterfeit cosmetics you use. You are using the counterfeit product, you have to be careful. And counterfeit auto parts, most of the time you can see these parts are being counterfeited by some companies. Wheels, filters, airbags. So if the airbags counterfeit, what happened? And counterfeit charges and batteries. A woman, Chinese woman, was killed by an electric shock after answering a call on her iPhone by charging with a counterfeit product, right? So very cheap. Right? To get counterfeit product, they charge right? Cost about 2,500. Right? If you go for genuine, it costs about 20,000. The difference, right? Functionality is same most of the time, but not long life, right? So, right. Right. Okay. We continue, right? This session will go on. Patents. So this question was asked in the piece also, right? A patent is an exclusive right granted by government, right? Government grants the right. For an invention which is a product or process that provides, in general, a new way of doing something. Right? New way of doing something. Or offers new technical solution to a problem. If you can offer a technical solution to any problem faced by human being, if you are using this laptop, to notice any issue, you can develop technology. Right? In the morning we saw a lot of hassles, a lot of issues. Think how to overcome these issues with the technology. And there are 3 criteria should be fulfilled to get a patent right. Novelty, it should be novel, inventive step, and commercial validity, right? Commercial applicability. It should be novel. The first of those criteria is that it has not been, right? It has to be novel. So meaning that the invention must never have been made before or carried out before. So I say. If it is in the public domain, you can get the patent. Say for example, you have some great idea, and what you do first is you publish a paper. Right? So you attend a conference and you write a paper on your idea, right? And you publish the article. And later you get know that so I can get a patent right on this. Then you file a patent application, and before your application to the office, so you cannot get the patents. It's already public domain now. Even though it is your invention, if you publish your technology before you file the patents, patent office will consider your invention is in public domain. Therefore, if you are planning to get a patent right on an invention, first file the patents, and thereafter you can make publication, so attend conference and share your invention. Right. So, scope of the claim. So, patent is granted on the claims you make on the application. Right? So, you do prior search and you do literature as you do literature. When you write your thesis, you do some literature and you establish the novelty of your approach. Similarly, so you look at other patents and you develop a new claim. So this is my claims. Right? New solution, new technical solution, new process. Right? So patent is granted on the claim you make with the application. If it is within prior, yes, you mention A, not now. Your idea is within prior art. If the idea is within prior art, right, you won't get the patent. So it's called outside the prior art. Prior art means previous patent documents. Previously published patent document. Also the inventive step, second criteria, it should be novel and must have been an inventive step. In other words, it must represent a sufficient advance in relation to state of art. Advance, sufficient advancements in relation to the state of art before it was considered for patent. Right? Sufficient advancement. It should be non-obvious. Right? So here we have got 70, 50 students. Right? So you all are second years applied sciences. You have done your A-levels in science. Right? It should not be that. Right? It should be non-obvious. Right? If one comes up with an idea, inventions and develop some technology, if everybody in this room can very easily, right, learn and develop the same technology, the patent office considers it has no inventive step. Your patent application will be declined by the office, giving the reasons. This is obvious. Obvious to person in scheme. Obvious to person in scheme. If it is obvious to person of ordinary skill in the field concerned, you cannot get patent right. So you all are in the same skill. But if there are 100 students, so all students cannot develop this. Only one can. Right? Only one can, and so one student has used his intellect to develop the technology. Right? And yes, so there are some methods used by patent officers to check with the novelty, the inventive step, general principle of assessing the inventive step determine as to whether invention in the claim would have been easily made by a person skilled in the art. Right? So patent office will look at, right, or determine as to whether the inventions in the claim would have been easily made by a person in skilled in the art. Assess each claim if there are more several claims. So they individually evaluate the claims. So why did you become a patent examiner? Because I love to tell people no. Right? So we always try to decline patent applications on novelty ground or inventive steps, even sometimes commercial applicability. Subject matter, right, which a person is skilled in the art would have easily made excluded from the subject, right? Subject to grant, right? So you want to be granted the patent. And industry applicability. So you should have some commercial value. So you fulfill your invention or idea fulfill too. Novel and test. But so you cannot use it, right, for the betterment of human being. People cannot use it. There's no any, right, value of the inventions. The third criteria needs to be industrially applicable. The invention should be able to commercially exploit. You should have some functional features. So if all these three criteria are fulfilled, so you will get patent right. There are some inventions you cannot get the patent right even, right? Patent office will decline your applications on this ground. Anything against well-established natural law. Example, a machine providing law of gravitation to be 4 is not patent number. Right? Newton's law, it's well established law. Okay? if it is full or to develop machines, right? So you won't get the patent right. Or you make some contrary to the public order. You are developing a technology to take your own life without any pain. Message to suicide, right? Without any feelings or pain. Right? So those are contrary to the public order. So, and also the image and method of committing suicide and sex determination technique to facilitate female feticide, enhance environmental pollution. Right? Female feticide. Right? So you develop machines to detect sex before the child is born, then you decide to destroy the fetus, right? Depending on the male or female. So this is seen in India, right? India, this is so these are not patentable, right? So even in technology that enhances pollution, environmental pollution. So these are also the aesthetic creations and your skills. You cannot get the patent right for the skills. A personal skill acquired by personal practice and cannot be shared with third parties. So you cannot get the patent right for the skill. Moreover, you cannot get the right for the speedballing skills. Baseball, right? Pitching leaves. So you can get right for the skills. So validity period of patent is 20 years. You have to pay annual maintenance fee. The patent is granted today, right? And after 1 year's time, you have to pay renewal fee, maintenance. And you have some options. Information disclosed. Secrecy, do nothing. So you don't want to get a patent right. And also you want, right? Others also not to get patent right. What you can do is, so you have an idea, you are not, right? You are not interested in getting a patent. Then you put it public domains. You share it in a conference or write a paper. Right? Then you publish it. Then even someone copies your idea, so he cannot get a patent because it's in the public domain. It is cheap, prevents others from patenting and does not offer exclusive right. You won't get the exclusive right. Previous prevention of competitors. Right? Secrecy. And cheap does not reveal the image. No protection against even reverse engineering. If someone developed it, no legal provisions. You cannot register it as a patent, but you keep it as secret. But accidentally it goes to third party. Or even someone reverse engineers it and you have no legal provision. Do nothing, no effort. Right? You idea kita kalau main nongkat, orangnya mana? Idea, bed kau ni dah, bukan. Bila tapi kain pocra idea sampai mana? Tapi kapan terus terang ni? Karena ni kalau di mana boleh kita idea kan ni kalau mulai ni kalau mulai. Tapi kita ni ke bed ni kan buat ni boleh kita. Boleh dia orang ni bed terus boleh dia orang dah. Ni mobile phone maybe more than 10 IPs protected mobile, not 10, 1,000. Right? Make software askan keluar even ringtone ni IP, right? Design ni right? Mana dia pun, kamu makai kalau dia desainnya gitu kan, bahan yang kena dipakai, karya develop kan itu kan modeling yang kan ini, you can develop. Yes. So this is whether to patent or get the patent right or not, it is not an individual decision. You can consult lawyers, market experts. Right? If in university you can consult even the faculty staff, UBLC. Right? So we give the guidelines. So idea behind patent system of the world is to encourage not just innovation but sharing. Right? So there are two objectives: encourage innovation, also sharing. So you can do a lot of, you can develop a lot of business models with the patent. You can license it and adopt it. Patent right is territorial, not universal. So that is one of the questions we ask. Majority asks, other way. True or false? 83%, right? Answer. Patent right is universal. No. Patent right is territorial. If you register a patent in Sri Lanka, right? So it is valid only in Sri Lanka. Right? So you can export the product to India, saying that I have got the patent right. Right? Someone may have, right? Sometimes you will be infringing patents, right? Violate the IP right. And priority date, the priority date of patent relates to the earliest filing date. Right? So if you file, say, this is right example. So this is very important. So why I am telling you to file the patent as early as possible to get the priority date. So assume you have invented products, right? And you have filed a patent application with Depot Sri Lanka for this invention in Sri Lanka 2022 January 2. And according to the market survey, you have found that this product has very good market in Thailand. Right? Therefore, you apply patent application in the Thailand IP office. There are basically Hatai Dase. Hatai Dase application yang nama, tapi Lanka file करना January 1. Basically product එක මාකට් එක තායිලන්ත මාකට් එකේ තියෙන නිසා අපි ජුලයි 16 ෆයිල් කරනවා patent එක Thailand receive. And by the time an inventor from Thailand and apply the patent for the same invention, they thus විසියකේ පහයි 20. That's what we see. It should be 22, right? 22, right? So you should file the patent as early as possible to get the priority date. So you have filed first patent, local patent, January 1st. So development Thailand වල දෙවෙනි application එක දානවා ජූලයි 16. ඒ වෙනකොට තායිලන්ත තේම ප්‍රෙසිඩන්ට් කෙනෙක් 22 5 20 patent application එක දානවා same technology. Who will get the patent right? තායිලන්ත කාටද හම්බ වෙන්නේ? කාටද? ලංකාවේ දාලා තියෙන නම් patent right කියන්නේ territorial right එක. මෙයා ලංකාවේ විතරයි පැයිසි. මෙයාට තායිලන්තේ ෆයිල් කරන්න ඕන කරලා ඒ ප්‍රොඩක්ට් එකට හොඳ මාකට් එකක් තියෙනවා. එතකොට මෙයා යනවා ජූලයි 16 ෆයිල් කරන ඒ ටෙක්නොලොජි එක තමයි. ඒ වෙනකොට තායිලන්තේ තව රෙසිඩන්ට් කෙනෙක් මැයි 20 ෆයිල් කරනවා. මේ දෙන්න කාටද හම්බෙන්නේ? තායිලන්තේ. private date කියලා කියන්නේ ඒකට private date එකත් එක්කලා you can claim the private date. ලංකාවේ private date එක මට තියෙන ජනවාරි 1 ඒ නිසා you get the payment. අරයට පස්සේ උනා payment එක දැම්මා payment right එක. So you have 1 year period private date. ඒ කියන්නේ ජනවාරි 1 වෙනිදා ඉඳන් දෙසැම්බර් 31 වෙනකම් ලෝකයේ ඕනම රටකට දානකේ private date එක හම්බෙනවා. I mentioned you earlier, according to Paris Agreement and other global treaties, so this IP law has been harmonized to a greater extent. Right? So down by World Intellectual Property Office, WIPO. So file the patents as soon as possible. Then if you file a patent application in the Thailand office, you can get the private note on our office and submit the application with the note, right? Private note. So these are some filing routes. You can write local patents, NIPO, and if it is international patent, you can go for WIPO, right? So World Intellectual Property Office. That is PCT group, we call PCT, Patent Cooperation Treaty. And even you can file patents application with the regional officers, right? And also country officers, USPTO, Korean office. Right? If you file one patent application, so this is why these are important. If you take PCT route, you can file. If you file one application, the effect will be nearly 176 countries, over the contracting countries to PCT. And EPO, if you want to get patent coverage for European region, Euro region, so you can put one application by filing patent application with EPO, European Patent Office. So these are like regional office. If you file a patent with EPO, European Patent Office, so you can then individually member state ABC. Even though you file one with regional officers, you have to file individual application again, right? So PCT route is beneficial. You can minimize the risk. Sorry, not risk, cost to a great extent. Right? And there are some other benefits also. You know, you should not translate the, if you want to say get ID right in China, you have to get Chinese translation. It will cost you know. But if you take PCT route, no need. Right? So this is some, right, I am not going in detail, we can, right? So this is the route, if you file international patents, I am not going in details, we have some more topics. Right, so if you file international patents, the WIPO, World Intellectual Property Office, will issue ISR, International Search Report. We call it International Search Report. I skip this. I'm not going in detail, right? So because it takes time to explain in detail all this, right? So these patents, you know, the patent family. What is patent family? The patent family is a collection of patent applications covering the same or similar technical content, right? So if you file one patent, so you can file so many patents with a similar technology. So then when you are key technology, you find several patents. Then others cannot develop it. So you expand your area broad. Then other competitors cannot access to your technology. So one product, you can see these several patents. competitors cannot access to your technology. You get several patents. Many computers go behind one customer. So we are in a very competitive world. Companies are chasing behind the customer. Then, so these are some contents of patent applications. Like claims. So there are type of claims, broader claims and narrow claims. So you can learn later. You can arrange workshop on patent drafting. Right? Taniya can help. Right. And patent infringement. So this is a property provided to you by the government. If someone is using your property without your consent, right, he or she is infringing your property, right? So you have legal right to stop if someone is using your property. Yeah, so invention A, B, patent known as A, B is inferior, right? B is using the features of the patent application A, B, C, D, right? Invention A. And invention B is using A, B, C, D plus E. Right? B is using all the features of A's patent. Then he is infringing. Right? So he had added one more claim only, right? One more claim. But he is using same features. So another example, I will share this slides with you. And public policy issues, the patent right to exclusive right. If you develop a technology, if you get the patent right, say for medicines, especially, right? The government has right to ask you to, right, give compulsory license to the government for pharmaceutical companies, right? So patent rights and patient rights. So on philanthropic grounds, so government can, even though you are given exclusive right, so government, anytime government can ask you to, you cannot get monopoly power on this invention, right? So in terms of the public needs, so you have to license, you are pre-licensed to government, or you are pre-licensed to the pharmaceutical company, right? Especially HIV drugs, right? So some governments objected getting patent. Even you may have heard about the COVID vaccine recently. Some companies, pharmaceutical companies like Biotech, Johnson and Johnson, AstraZeneca, they developed some vaccines. World Health Organization asked these companies to waive the patent right? Waive the patent right. But they didn't waive it. But even though they waive, so we cannot develop drugs. They can waive it, right? So we cannot maintain the quality and we cannot develop as developing countries. Government can ask patent holder, please, you should give royalty license or pre-license to the government on philanthropic ground. Patent information set, we come to that later. So these are not databases. Taniya will do that. So IP, yes, ownership dispute of IP. So this is important for you. Right? Ownership. So according to our IP policy, we have an IP policy. A research funded by the government. Say you are doing research and funded by the government. who will own the ownership? Who will own the IP right? How the IP right take අපි ડોક્ટર තේරෙන්නේ රිසර්ච් එකක් කරනවා ගවර්න්මන්ට් එකෙන් ෆන්ඩින් දීලා. මොකද කාටද ඒ කියන IP එකයි ගවර්න්මන්ට් එකද ප්‍රොෆිට් දෙන්නේ. So in doubt how we එතකොට අපි රිසර්ච් ඇග්‍රීමන්ට් එකේ සයින් කරනකොට ඇග්‍රීමන්ට් එක තමයි ගවර්න්මන්ට් එකේ ග්‍රාන්ට් එක දෙනකොට okay you can get the IP right. So ඒක තමයි බලාපොරොත්තු වෙන්නේ. And research funded by university, you are one of the students. The students get a grant from the university. So you develop a technology and you get a patent right. You apply for patent. So according to our IP policy, if you are a student or an academic, if you get a grant from the university, so any IP generated out of your research should be owned by the university. Right? It is applicable to even your final year project also. To do a final year project by using the university labs and resources, even your research is requested by an academic. Right? Then IP right goes to the university, but you can enjoy the 80% of revenue generated by the IP in commercializing your IP. Okay. So you can go through the IP policy of the university. This is funded by funding agent. How we negotiate with the agent, right? This is funded by industry, right? So these are some. There are two module inventor on module and institution on module. So why you should choose institution or model? So filing cost will be borne by the university. If you come up with an invention, if you notify it by filing the invention disclosures, so we take up the process. And as is in prior research, even we draft the paper, we have to draft the papers and we do pre-run to operate search. Right? And IP is maintained by the university. We pay annual maintenance fee. You should not pay, so we pay it. So actually involved in licensing process. Right? So if you get a patent right individually, right? So you have to negotiate with the companies alone. But on behalf of you, we negotiate with the companies. University. The university का जाने में तो बड़ा क्या companies they are in number. You should always go for institution or model, right? So IP landscape, right? You know now we are in the 21st century, right? So artificial intelligence is dominating human brain. AI will reach human level by 2029. That's the focus. AI is the greatest threat against human. So companies will hire AI, not people. Right? If the machines can do tasks companies by people, why should companies hire people? No, it's right. So they can instruct the machines to do. And AI would be the worst event in the history of our civilization, given on. So this is the world where we are going towards. So this is not AI is a world phenomena. Even the world. You may have seen right, AlphaGo competition. AI defeated right, world Go champion 3 times. AI won the. So it's a harder game, like chess. Right? And even like AI can replicate singer's voice as it is, single voice. Right? one invention. Inventor is an AI. So one liquid container, right? So issued by this is international application, yeah. WIPO, yes, AI, A1. The inventor is AI. Liquid container with some functionalities. Yeah. So AI, some cases, how the inventorship is defined by IP officers in the world. Right? AI cannot be listed as an inventor. AI cannot transfer property right to the applicant. Right? UK, according to UK IP law, so how they have defined inventor? Transfer. Disclose information to the IP office. AI cannot do that. Therefore, right, they cannot consider as an inventor. Right? USPTO. Inventor is limited to a natural person. So therefore they have declined the application. Inventorship is limited to natural persons. Right? So, but there are still some arguments. Inventorship, AI as a tool. Some define AI as a tool. So antigen into animal to produce antibody. Who is the inventor? Animal. The person doing the experiment have the right to get a patent right. So here the cow is considered as a tool. So still there are some controversies whether the AI can get a patent right. Can a person claim for something that he has not invented? The patent is granted on intellect of mankind, or person. Only natural person can be listed as an inventor and can transfer the right. AI is similar to experimental animal in that it contributes to inventions as a tool. Right? Experimental animal. Cow is an experimental animal. Right? So this is the trend. So more AI, number of AI applications for AI based technologies. Right? So here, so more patents are filed by countries. US, the highest. And even the gap between scientific publications in the area of AI and patents in the area of AI, you can see the gap is narrowing down. Right? Almost 3,000, 4,000 patents and more than 1.6 million papers. Right? Average annual. So now you know the more than the scientific publications. Now trend is people are filing more patents with AI technologies. That's right. So these are some jobs have increasing demand, some jobs have less demand in the 21st century. Increasing demand, decreasing demand. Decreasing data entry clerk, no demand will be decreasing. Administrative and executive secretaries, accountants, auditors, new demand, increasing demand, data analysts and science, AI and machine learning specialists, big data analysis. So these are the emerging jobs in the world nowadays. some jobs are vanishing. So we are in this is the first industrial revolution. Farmers became industrial labor during first industrial revolution. And the second industrial revolution, some factories emerged, electric generations, the second industrial revolution. And third industrial revolution, computer music, computer technology. And now, fourth industrial revolution, 10 years later, by 2032. Yes, they control the knowledge age. Welcome to their world after 10 years. So this is the trend now. Right? Okay. So world is rapidly changing. As universities, we have to be ready. We have to incorporate new subjects into curriculum, and we have to differentiate what demand for these jobs are increasing, demand for these jobs are increasing. Accordingly, we have designed our curriculum. Right? Okay, that's all. First session. Right. Okay. Any question? You can now say. No? Any question? Yes. Any question? Not pasti mana? Tapi hilang saja itu disediakan. So we can do some break क्या करेगा ना? Oh, any question? Mana pasti no? Hah? Oh iya, pasti. Oh isu. Yes. Any question? So I skipped some slides because of the time limitation, right? So, but I think we got some understanding about the role of the UBLC, and if you have an idea how I get the protections, right? If you need more consultation, you can visit the UBLC, right? About this. Anyone have you seen our office? Dekak tidak apa office ni kita? Kuitin, ha? UBLC ke dekak tidak tahu apa? Ikan ni mana tu? Ada tu? Ada. Oh, ada. Ada mana lasan office ke? Office ke lasan ni, bayi. Tapi kerana ada lasan ni. Api podi office kai denai ini office ki, namun tapi dah विश्वविद्यालय tak orang dia tu langsung visika. Api misalnya udah utik kala विश्वविद्यालय में दाखला langsung visika orang dia produk dan hayat market tek itu. Dayarathne ini awal tu natura tu. Podi kamar di Dayarathne office kan, namun tapi saya progress ya Dayarathne. Ini memang kian siswa asing dan මේ setup එක හදලා තියෙන්නේ academic set විතරක් නෙවෙයි. බහුත් අපි වැඩිපුරම ප්‍රතිලාභ දෙන්න කැමති ළමයිට. මොකක් හරි ඉන්ෆර්මේෂන් එකක් අරගෙන ඇවිල්ලා මේක ඩෙවලොප් කරලා පේජ් රයිට් එකක් මේක සර් අපි කමර්ෂලයිස් කරන්න පුළුවන් බලමු. ඒ කතාවලත් අපි ස්ටාර්ට් කරනවා process. මේ කමර්ෂල් පාර්ට්නර් කෙනෙක් අල්ලගෙන අපි concept එක දුන්නාට පස්සේ ඒක ප්‍රොඩක්ට් එක ඩෙවලොප් කරලා ඉන්න මාකට් එක දානවා. මාකට් එක දානකොට සල්ලි එනවා. ඒතකොට මේ විශ්වවිද්‍යාලයේ අවුරුදු 4 ගියාට පස්සේ මට නැති වෙයි එහෙම කන්නේ. ජීවිත කාලෙම හම්බ වෙනවා. තමුන්ගේ ජීවිතයෙන් පස්සේ වුණා තමුන්ගේ දරුවන්ට මේක හම්බෙනවා දිගට. අපි ඒ විදිහට සෙටප් කරලා තියෙනවා. ඒ නිසා විශ්වවිද්‍යාලය යන්න කලින් උපාධි සහතින් අමතරව අඩුම ගානේ මොකක් හරි ඩෙවලොප් කරලා පේටන්ට් එකක් අරගෙන ප්‍රොඩක්ට් එක කමර්ෂියලයිස් කරන්න බලන්න. එහෙනම් අඩුම ගානේ පේටන්ට් රයිට් එකක් පේටන්ට් එකක් අරගෙන යන්න you will be demanded by the industry. Industry ලොකු demand එකක් තියෙනවා. We'll have a break and here. Apply card. Huh? You are 30. Right. So we do some search activities. How to use patent databases to, if you have an idea, how to see whether it is novel idea or not. Right. Whether this idea is already patented or someone has taken the patent right on the idea. Right?
Get any idea to into your mind. So what should we do at first? Suppose you want to find something, you want to invent something, you want to make solution for a problem. What did you do? What should you do at first? Before we get into that, so we have to check whether that there is any invention invented in world anywhere in world, whether that problem is already solved. So for that we have conducted the patent information search. So actually the patent information search means like the research literature search. The patent information search means that we have searched by using the several databases that whether there are any related patents, whether there are any prior arts related to our invention. For that we can use the several databases. There are free databases and also the commercial databases. So free databases means SpaceNet, PatentScope and USPTO lens. So when you get into the Google or some search engine, you can just search those databases. And also there are commercial databases. Those are Derwent Innovation Q+, Dialog likewise. The commercial databases we have, if we want to use that, we have to pay. We have to give the annual fee for that. Actually in the university, UBLC, only the UBLC have the access to those databases. So if you need to go do a search through those databases, you have to come to visit our unit to do this search through those databases. So here you can see this is the typical structure of the patent application. This is the patent application filed at United States. So you can see here the first inventor, it means the principal investigator of the invention, and also the title, and other inventors of the patent, and also the assignee. Assignee means that we can give our patent to any company or the university or any other party, third party. We can assign our patent. And at the moment that when we assign our patent, he is the owner of the patent. So then the patent.
When we assign patents, we transfer the ownership. But when we license the technology, so we temporarily grant the license to use the technology for limited period. But when we assign the patents, so you have a patent. You assign your patent to Apple. Then you transfer the ownership. But when you license, still you are the owner.
And patent application number, there are several numbers that own to a patent application number, and the patent publication number. It is, you can see in the upper portion in the page, the US 2212. So it is the patent publication number and also the patent publication date. IPC number, it is the patent classification number. We can, through those classifications we can search our invention to find what is the field that our invention belongs, and also the CPC number, corporate patent classifications, and also this is the abstract. This is the front page of a patent application. And So when we come into the patent search, there are several search types. We can go through one by one. So the first one is the state of art search. It is the actually if you want to do the state of art search, it is the first stage. So suppose you are in students in the food science department, and so also you have assignment. You have an assignment to conduct invent something by using the cinnamon. Invent a beverage by using a cinnamon. So for that, you can go to that the databases I earlier mentioned. You can go to that those databases, and through those databases, you can find there are whether there are any inventions invented through that area. The beverages incorporated cinnamon. So did you take your laptops? And also I hope you got this tutorial, research activities tutorial.
State of art search.
So we can practice that state of art search. You can just
Mobile එකේ පුළුවන්
even in the mobile you can.
difficult to read, you can use.
So our first question is, assume you are a manager of a branch of a company whose business involves solar and wind powered electrical generations. Here you might want to do a state-of-art patent search using the word solar, power, electric and generators. So suppose you are the manager of that company, you want to search that whether there are any inventions related to solar power, electric generators. For that, we can go to the database. Here I use the free database, namely SPaceNet. In your search engine, just type SPaceNet.
So this database composed of nearly 100 billion documents, nearly 100 billion patent documents. Now we are searching some terms. There are Boolean, Booleans. We are using Boolean operators. Boolean operators means we are using an or. Yeah. Then solar and power and electric and generators. If you are using and, you will get less results. If you put O, you will get more results.
For search, you can click the advanced search.
Click on advanced search. Advanced search.
And then go to the title or abstract dialog box. Then go to the title or abstract dialog box, because we want to get wider result. If we put our key terms in title dialog box, we have the result is very minimum. So therefore, if we want to get more result, we can use that title or abstract field. And also here you can see there are several fields. You can use such fields to search the title, abstract, description and claims. So you can get more results by using those fields. And also there are names. Names means that you can search your patents by using inventor name. If you know about your inventions, inventor name or applicant's name, or applicants means most of the time the applicants are either by university or the company. And also if you want to know about the total patents now count of a company, you can just search by using this. And then for this example, we use the title or abstract. type solar. Since you want to find the inventions in the field of solar power electrical generators, you can type solar power electric generators. Then you click search. So here you can see 3049 are resulted through this by using these key terms. So suppose if you want to get more narrow, to narrow down your result, you can use the Boolean operators. So by using the AND Boolean operators, you can narrow down your result. By using OR Boolean operator, you can widen your result. So you can see the results are narrowed down 468 results. So if you then you have to check the one by one whether to find the inventions related to that your area. Just click on one that title and then here. So you can see the details of this patent application. So this is in the reactive power compensation for auxiliary actuator in a solar or wind power station. And also you can find the legal events. I mean that we can see the patent is activated or patent is deactivated. So here, the application is refused. Therefore, we can assume that application is no more in the activation process. Did you understand? If anyone didn't understand anything, you can ask a question, you can ask for the clarifications. Shall we go to the second one? Or you want more time? At the first stage, you can use that state of art search. So you want to find the inventions related to a specific area, but you want to know about the inventions that are already invented. For that, you can use this state of art search. And then the second one is the patentability search. The patentability search means, so suppose you have invented a novel product. So after inventing it, you want to know whether the invention is actually novel. I mean whether the invention is new to the world. For that, we have used the patentability search. We can consider the example. Your company is in the business of manufacturing power tools, drills. One of the engineers has come up with the idea of incorporating a level into a tool sometimes called a split level or bubble level, to make it easier for the user to align the tool accurately. She wishes to know if her idea is patentable. In here, the invention is already invented, but in the previous one, the invention is not invented. Actually, the concept is we have the concept, but the invention is not made yet. Here I will use a different free database. In your search engine, search patents form. Hope you all got into the database, and then click the search and then go to the advanced search. Sorry, field combination. Here you can see there are several fields. You can use as the space net, you can use the several features, several key terms or several application publication numbers to search your patent. Okay, so due to the limitation of time I will go through quickly. So for this example, please type, please search in this field English abstract, and then type drill split level. So here you can see there are only 3 results. There are only 3 inventions related to that area. By looking at those 3 results, one by one you can check to check whether your invention is same as the inventions that are already exist. In patent scope, you have a very advanced feature that when comparing with the SPSnet, you can get the you can get the summary of the patents. I mean that here you can see what are the countries apply the patents for related to that invention, and also who are the applicants and inventors, and also you can get that result by using the chart types. So suppose you want to do a research in that area, the patent scope database is very useful because it gives us a summary, it gives us an analysis of total number of applicants and also the inventors, companies. You can also download the original document in that patent scope database. During your leisure time, you can deeply go through those databases. And I will move to the next part. This is the validity search. Validity search means, so if you want to, suppose you have an invention, and also you have filed a patent application for your invention. But during the patent examination, the patent examiner find that there is an invention related to your patent application. Therefore, you have to justify that your invention is not same as the invention that examiner found. So, for that we can use the validity search. There is an example. Suppose you are working for a bicycle manufacturer and you are intending to export bicycle for the first time to a particular country. You have carried out a freedom to operate search and found a patent in force in that country that you think you are at risk of infringing. For that, I will use the patent scope database. There are several patents that related to that magnesium bicycle frame. So one by one you can check. And also the most important part is in this search. Most important part is claims. You can just go to the claim part to check whether your invention is novel comparing to the invention that already filed. Here you can see the claims are resided in Chinese, I know the language Chinese, maybe Chinese. So here the patent scope database has the feature that you can translate this into the English. So here, to justify your inventions, the main thing is you want to read the first claim. The main point of this is the first claim includes all technical part of other claims. The other claims are depend on the first claim. So you can just see one by one, you can just check the first claims of all patent applications to justify, to secure your patent, justify your patent by other patents. And also other search is name search. So suppose you know about any inventor who invented something, or you know about any company. So for that we can use that name search. We can enter directly the name of the company or the inventor here. Applicant name. I want to know about the total patent count that filed by Apple company. So I entered Apple Inc. Then search. You can see here they have filed, throughout the time they have filed 61,869 patents. So it is this name search. You can get the brief analysis of about those patents, who are the inventors, what are the countries, and also the charts. next one is the technology activity search. In here, suppose you are in a very specific technological area, so you want to know what are the inventions in that area. So for example, you are active in the field of beekeeping, and perhaps your ancestor have taught you that honey can be helpful for healing wounds when applied to skin. For that, you can search what are the medicines, medicines incorporated honey that are already existed in already invented in the world. So here you can see we use this search term medic and honey. You can see here this star mark, we call that as the wild card. So medic means the stemming word of medicine, medical. There are several words that start from this medic word. So here you can see there are 14,047 results in the field of the medicines incorporated honey. And also the other search is freedom to operate search. Freedom to operate search means, suppose if you want to export your invention, if you want to export your product into other country, and you want to know whether there is any patent filed in that country, also whether that your invention might be infringed by anyone's patent. For that we can conduct the freedom to operate search. We have included some examples in that search activity tutorial. You can, during your leisure time, you can freely go through them and search them. Those are the different types of search activities. I hope you got a rough idea about these search activities, and also you can visit our unit to get more further clarifications about this.
Right. I think now we can finish the session. So this is we shared with you a very narrow content of this area. It's a very vast area. If you have any issue, any problem, any question, you can ask, or you can come to UBLC. It is close to CODL. Have you seen CODL? Next to CODL, our office, right? So you can access to our website. You can get a lot of information, right? Hope that at least some students will, after this session, at least some students will come and inquire about how to get patents. I have this invention, whether this is patentable. So what should I do to get a patent? So we hope that you will come with these queries to the UBLC. Right? Yeah. So we have another session, but the thing is now due to time limitation, how to form a startup company. Right? So guidelines to form a startup company. So no time to do that, and we can individually consult you if you come and say I want to start a startup company, then so we can individually assist you, right? Consult you, right? No issue. Okay, then so we can wind up the session. Hope that you learned something, the role of UBLC, and about intellectual properties, or patents, what is a patent, how to file the patents, how to develop a business model with the patents, right? So you learn, you got some understanding, right? Okay, right. Thank you.
you, sir and madam, to the unfolded word for us. We are grateful for the time and effort you took to share your thoughts and knowledge with us. I'm sure that this will help our students to pursue their dreams. Next, let me invite Dr. Taniya, who is the Senior Lecturer in Department of Food Science and Technology, as well as the Coordinator for UBL Linkage in Faculty of Applied Sciences, to deliver a word of thanks.
Okay, good afternoon everyone. So, marking the end of today's workshop on intellectual property protection and management, let me thank those who have joined hands to make this event a success. So first, I'm thankful for our Dean, Prof. Indunil, for the support he has given to organize this event at the faculty. And then I'm grateful for the Director UBLC, Prof. Dayarathne, and the cell manager, Ms. Taniya, for accepting our invitation within short notice and also conducting a successful and productive workshop. So then I'm also thankful to the Students' Union of the Faculty of Applied Sciences for taking the initiative to arrange such an important workshop for the students of the faculty. And then I'm really thankful for the students for being here with us today and for your active contribution to make this workshop a success. Thank you.
Thank you, madam. On the behalf of the Research Bureau and Education Committee of Faculty of Applied Sciences, I would like to thank Professor Indunil and Ms. Taniya Sankalpana for your wonderful session, and Senior Lecturer Dr. Taniya for making this event possible. Also, we would like to extend our gratitude for Professor Indunil, Dean of Faculty of Applied Sciences. We truly appreciate your joining us at our special event. Thank you from the bottom of our hearts for being part of what is believed to be a wonderful beginning. We would like to say thank you all the attendees for taking the time of your day to grace us with your presence. We hope that you all got some valuable lessons from today's webinar. Thank you again, and we hope to see you again at our next event. Until then,